Good afternoon, everyone. My name is Bob Kim from Education Law Center. I'm here with Kevin Welner from National Education Policy Center. We'll get started in just a minute. I think we're quickly populating with the participant list. So I see the number rapidly rising. So welcome, everybody. I think because of the length of today's presentation and we really want to get to a bunch of really important topics, I think we're going to get going right away, even as people are with us and still joining us at the top of the hour. But again, my name is Bob Kim. I'm Executive Director of ELC. What we are talking about today is actually the third of 3 webinars to get the discussion started about what public education supporters and advocates can and must do as we anticipate the second Trump administration. If you missed the first and second webinars in the series, you can access the recordings using the links in the chat. So we encourage you to go back and look at the first 2 webinar sessions, which dealt with school funding issues and also dealt with the voucher threat that is emerging and continues to be with us. So again, those are the first 2 webinars. And today, our webinar is focused on student civil rights as we prepare for the Trump administration. What do we do now? Students' rights are civil rights. We are joined here today with Kevin Welner, whose bio we will put in the chat. We're also going to be joined shortly by Assistant Secretary Catherine Lhamon, who is the outgoing chief of the Office for Civil Rights at the U.S. Department of Education. We'll put her bio in the link as well. I'm told that Catherine is as you might imagine, engaged in a few other activities in these last 48 or 72 hours. So she will be joining us shortly, midway through. And if you have questions for any of us, myself, Kevin, or Catherine, we encourage you to put those questions in the Q&A link, not using the chat, but using the Q&A button. So please feel free to do that at any time. And as we have time, we will get to those questions for Catherine or for me and Kevin at the end of toward the end of the webinar. So with that, I will just get started here to give you a brief intro about student civil rights. And in particular, we at Education Law Center have been working pretty hard on some of these issues over the last year or so, as have many of you out in the field. If you don't know, by way of introduction of about what ELC does, we both do individual student cases around student rights, ranging from issues that are faced by students with disabilities, students of color, other students that have civil rights concerns, and we do intakes and sometimes directly engage and represent those students. We also do class action suits for surrounding students with disabilities. We do handle cases pertaining to English learners. We're involved in 2 racial desegregation cases in Minnesota and New Jersey. We have been working to address censorship laws in states around the country, those that prohibit discussion of topics related to race, sex, and LGBTQ issues. And then finally, and relevant to today's conversation, we've been working through legal concerns posed by the incoming Trump administration related to civil rights, student civil rights. And we are, I know, in conversation already with many of you on this webinar today, with other partner civil rights and legal organizations. And we have many concerns that we've been working on. And I'd like to, as we open up here, just briefly mention some of these concerns posed by the incoming Trump administration. And hopefully we'll have time to sort of engage and sort of get in further depth on these questions with both Kevin and Catherine. So to begin, I would like to say the obvious, which we all know, and we've all been, I think, in several webinars and conversations about the incoming Trump administration already. It's clear that we are entering a new era with vast civil rights concerns. Not only what may happen in the courts, in the federal courts, in the US Supreme Court, but what may happen in our new incoming Congress and the executive branch in the White House. Uh, Actions that may deeply and will deeply impact public education and student civil rights. As I wrote in a book that came out a few years ago called Elevating Equity and Justice, how students are treated in schools and whether or not their civil rights are honored and enforced is a reflection and really an indicator of how much our society writ large values equity and civil rights. Students learn and pick up values about equity and civil rights through how they are treated and how they observe others are treated, their peers, and valued by the adults in the school environment. So students are always learning about civil rights and the value of civil rights in their daily school experiences. The concerns that we've been tracking, and I'm curious what many of you have been tracking that may complement or be in addition to these, include, first and foremost, the issue of immigrant students' civil rights. We know that there are specific actions related to undocumented students that are significant in terms of the possibility of stepped up immigration rates that would be targeting undocumented students as well as their family members. And also, because of all of this stepped up activity and animosity, there's related school climate concerns, whether students who are undocumented or even documented students would be feeling hostility or experience bullying and harassment in the school environment. There's also concerns around, obviously, LGBTQ plus students. We know that Title IX has been recently re-regulated, and there's a strong possibility that there will be announcements forthcoming as early as next week to undo or redo yet again the Title IX regulations, which during the Biden administration were made clear that they apply and extend to protecting LGBTQ plus students from harm or discrimination in the school environment. We also know that there's concerns for students with disabilities, specifically funding concerns around the IDEA and also the civil rights protections that are enforced by the current Office for Civil Rights. Around issues of race and ethnicity and shared ancestry, there are concerns related to what might happen in the future around further application of the Harvard affirmative action case to both, application and enforcement of that case, that Supreme Court ruling, to the post-secondary environment, and also how it might extend to K-12 school diversity decisions made at the K-12 level. Other issues around race involve student discipline, changes to rules around school climate with respect to students of color, and also around changes about how students with shared ancestry and religious identity, about how there might be changes in enforcement around cases that pertain to those students as well. So I could go on and on. We have, concerns about censorship, the revived censorship laws that were enacted during Trump 1.0, digital privacy rights, which many of us haven't really touched upon, but as we enter an era in which online technology and devices become a bigger part of the education landscape, and the social media private sector becomes more and more embedded in the federal government at the highest levels, will privacy laws and enforcement at the federal level, how will they adapt to this rise in online technology, and will student privacy rights be enforced. And then finally, as we begin a conversation with Kevin and with Catherine later on, we are really deeply focused on the impact on student civil rights enforcement because of pronouncements to shrink, even eliminate the Federal Department of Education, and of course, the Office for Civil Rights, which is a very big player and component of the Federal Department of Education. And it's not just OCR within the Federal Department of Education that could be impacted, but many other agencies that and units that that relate to and have some role in enforcing student civil rights, including the Disability Office, the English Learner Office, and other parts of the department that really serve and engage in activities related to at-risk or underserved student populations. So those are among the concerns that we have. I think it's a pretty long list. But without further ado, I think with that opening, I'd like to turn over and engage our first panelist, Kevin Welner, on a specific aspect around student rights, which is the potential expansion of voucher programs under the Trump 2.0 administration. So Kevin, welcome. Good to have you on board here in the discussion. So it's interesting because we talked about vouchers during an earlier webinar, but for today's purposes, we're talking about vouchers in the context of civil rights and student civil rights. You are an expert on vouchers, including legal and policy and research developments related to voucher programs. How should we be thinking about vouchers in relation to student rights and in relation to educational equity and non-discrimination principles generally? What's coming down the pike, in your view, that we should all be worried about?
A lot, but let me first say thank you for setting up this conversation. I look forward to learning from you and Catherine, and hopefully the Q&A later on. So you mentioned the issue of voucher expansion. There is a very important federal element to that I want to talk about, but let me first speak about that in a broader sense, because most voucher policies thus far have been at the state level. What I've written about is something that I call the outsourcing of discrimination. So if we think about anti-discrimination or civil rights laws right now, they focus on protections in public schools. So we have the Equal Protection Clause, we have the Fourth Amendment search and seizure protections, we have free speech and expression protections, we have civil rights statutes like Title IX and Title VI and Section 504, and of course we have IDEA. And there are also various state protections, constitutional and statutory anti-discrimination protections, all of which generally apply to protect students in public schools. And most of these protections are lost when students move to private schools. I should note there are some important but small exceptions. If the private school accepts federal money, and most do, and if the private school is secular, if it's not a religious school, which is a relatively small subset of our private school sector, secular being the small subsection, then the private school has to comply with Title IX and with ADA. And all private schools that accept federal money, including religious schools, secular and religious, have to comply with Title VI, which again that we're talking about race, color, and national origin. And in a watered down way, they also have to comply with Section 504, which is anti-discrimination protection for students with disabilities. So when states, shift public funding from public schools to private schools through voucher policies, they're removing a broad swath of those protections I talked about. And while government can't engage in all these forms of discrimination that are protected there. Well, the government can't engage in those forms directly. They can outsource the discrimination to these privately run schools through voucher policies. So I think for some lawmakers and voucher advocates, this is a problem that they'd like to address. For others, I think it's a feature, not a bug, particularly when it comes to discrimination based on LGBTQ plus status. And of course, lawmakers, I should add, when they create a voucher policy, they can attach strings to public funding. That's essentially what's happening with those statutes I talked about, Title VI, et cetera. But most of today's voucher laws have only a minimal amount of strings attached. And some of these laws are actually very careful to essentially state that anti-discrimination protections do not attach to the voucher money. And maybe that's a good segue into the federal, the proposal that is going to be, I think, considered fairly early on in the new administration by Congress. It's currently called the Educational Choice for Children Act, or ECCA. And one of the provisions in the ECCA, it prohibits any state, federal, or local control over, quote, any aspect of any private or religious, and notice I said private or religious, so this includes the secular schools receiving the money, elementary or secondary educational institution in the program. That is, there is no application of anti-discrimination laws that would attach to the receipt of this federal money.
Yeah.
The federal money in this case is, I can get into the details, but it's what's called the Scholarship Tax Credit or Neo Voucher Program. It's a dollar for dollar federal tax credit that is used to bring money in to fund vouchers. And it would actually, it's huge. It's currently has a $10 billion price tag, which would approximately double the current number of students receiving vouchers across the US. So if this passes in its current form, it would greatly expand vouchers and greatly expand, therefore, this outsourcing of discrimination. And Bob, jump in at any time. I'm just gonna keep going if you don't jump in.
I just wanted to say, so you're setting the landscape here for a federal voucher program that could apply to any state, even states without a voucher program currently. So we have this federal overlay on top of existing and expanding state voucher programs.
Right.
So that's for sure. So give us a sense of like the number of students that might be involved in this that would then get taxpayer money essentially to attend school environments that you're saying are not only not subject to these anti-discrimination principles, but in some cases that's part of the design that you're saying to not include anti-discrimination principles.
Yes, yeah, and I can't. Sometimes there's a stated objective to discriminate, but very rarely do you hear people say that. SGOs, or scholarship granting organizations, the nonprofits that the money is filtered through in these scholarship tax credits, they exist already in 22 states. And so if you're talking about this program, those 22 states already have the infrastructure set up. SGOs would expand into other states if this policy came into being. With the $10 billion cap, to answer your question specifically, that's about 1 million vouchers if you assume a 10% overhead, that's $9,000 each for each one of these neo vouchers. And that's 1 million. It's a rough estimate in terms of the number of vouchers, but there's currently about 1 million out there, and this would double it.
Yeah.
So yeah, and one question is whether voucher legislation is, even if the voucher legislation is written to include the protections against discrimination, there is a second question that comes up, which is whether the Supreme Court would find any of those sorts of protections to be unconstitutional as a violation of the Free Exercise Clause of the First Amendment. And I should note, and you know this because ELC filed a brief in the case, but oral arguments were heard earlier this month before the First Circuit Court of Appeals in Boston in a case involving two private religious schools in Maine that specifically allege that they are being prevented from participating in the state's program. It's called tuitioning. It's the program that provides public funding for private schools in Maine, the one that was at issue in the Carson v. Macon case decided by the Supreme Court a few years ago. Um, they're alleging that they are being prevented from participating, arguing that the state's anti-discrimination statute discriminates against religious schools that hold faith-based views about gender and sexuality that are in tensions with the provisions of the Maine anti-discrimination statute, right? So, and I should note that similar issues are being litigated here in federal court in Colorado, challenging the enforcement of Colorado's anti-discrimination laws as applied to church-run preschools. In 2022, Colorado adopted a universal preschool policy that includes public funding for private preschools, including those run by churches. So a case currently before the 10th Circuit Court of Appeals, which is here in Denver, asks the court to hold that preschools participating in Colorado's preschool program can legally exclude children from LGBTQ plus families if they have a faith-based rationale for that exclusion. So the school, again, is arguing that Colorado's anti-discrimination law can't be enforced against a Catholic preschool that has a faith-based policy of discrimination against LGBTQ plus students. And again, the argument is that enforcement infringes on the church's right to participate in the government benefit program without having to disavow its religious character, forcing an unconstitutional choice of abandoning religiously motivated practices or foregoing the public funding.
Yeah.
So I see that Catherine just joined us.
Hi.
Hi, Catherine.
Hi, Catherine.
Hi.
Well, Catherine, we'll get to you in just one second because I have a big
Okay.
line about you. But I wanted to finish with Kevin as he's talking about the expansion of voucher programs and the fact that there's a religious component. As we know, most private schools that get voucher money, either whether in the future federally or from the states, that most of those schools of recipients are religious schools, and they have certain rights and certain exemptions from federal civil rights laws and state civil rights laws. And so what you're describing, Kevin, really is sort of this, as you put it, the outsourcing of discrimination to a sector that by design and including with the religious component would be excluded from so many of the laws and enforcement that Assistant Secretary Lhamon and OCR have been so diligently pursuing over the past 4 years, and then prior to that we can even talk about. But so I think it's a good segue, if I may segue, that the voucher threat is one that is a great concern to all of us civil rights advocates in the field, because it makes it extraordinarily more difficult to ensure that those students are safe, that they're treated equally, equitably, and that we can do things when we know that those schools are not acting the way that they should. So thank you, Kevin, for that introduction, and welcome, Catherine, to our conversation. We are here with several hundred advocates and friends from around the nation. Your introduction has already been mentioned, and your very illustrious bio is in the chat for all of us to know. But I will say, as a point of personal privilege, that I've known Catherine for many, many years now. I worked with her in her OCR 1.0 stint, and you are and have been, a real touchstone and influence on me and my career. So I thank you so much for being here with us, all of us, especially given what you must be going through in the last 48 to 72 hours of your time at OCR. So welcome.
Well, thank you for having me. Thank you all for coming together for this important conversation too.
I note that you have just recently announced your 4-year retrospective, all your work. And if you don't mind, and I know you're going to probably talk about this anyway, but I just want to remark on how amazing some of these numbers are of what you've been able to
Thanks.
achieve in the entire Office for Civil Rights in the last 4 years. I'll just note really quickly the highest ever number of complaints per year for the past 3 years, 56,000 total cases resolved. Is that
Yes,
that's not a
yes,
misprint?
yes,
That's
that's
not
not a misprint. Yes.
129 proactive compliance reviews engaged in and 114 resolved. And those of us who know OCR know how amazing and important the affirmative investigatory work under compliance reviews is. The shared ancestry or ethnicity focus, the stunning number of resolutions, including very recent ones in higher education at UW, Rutgers, UCLA, Lehigh, and Johns Hopkins, if I can name those.
Sure, and
Um,
we just announced one at Emory, and like maybe 10 minutes ago. So
yeah, I was trying to be up to date, and
you can't, you can't.
you can. I can't keep up. Um, and then also just two more things. The civil rights data collection you announced today, the release of the 21-22 CRDC data and next steps on the future collections. So,
Right.
very important announcement. And last but not least, let's just throw in 64 policy resources, including very recent ones on post-secondary disability guidance, Title VI hostile climate, and Title IX online digital harassment. So, wow. Can you just talk to us about any of those accomplishments that you want to mention for the good of the order here? So I invite you to talk about any of those, but I first
Thanks.
also want to ask you generally, like, how are you feeling as you close out your second stint as the head of OCR, and this is also, by the way, a little more bittersweet, your second experience transitioning outside of OCR as you have an incoming Trump administration.
Yes.
So,
Yes.
how are you feeling at this moment as you sit in the last sort of 48, 72 hours?
Well, thank you. And thank you for having me. Thank you all for this important conversation about the issues that we love, that, protecting civil rights in schools. So I very much appreciate being able to have my last conversation like this in this role with you all too. So thank you for it. And how am I feeling? I mean, I feel enormous pride in and gratitude to the people in OCR for the work that they've done. And I think that the 600 of us are so well poised to meet the moment in terms of the volume of civil rights need and the scope of civil rights harms that we're seeing in schools. And so I'm so grateful for that. And the 4-year retrospective report that you just described, I think those numbers, I think the cases described in the report, the work described in the report reflect that the Office for Civil Rights is open for business and ready to meet the scope of harms. And I also, I love this office. I didn't want to leave it. I had been planning to be here for another 4 years, and so it is more than bittersweet for me to have to walk away. I walk away knowing that the people in OCR are ready, capable, willing, expert, amazing, and can do it, and can do this work that I love without me. And I would have loved to stay and to still be here to join them, because I think that the quantum of harm that we're seeing in schools is in itself astonishing, and the quantum of harm that people trust the federal government to respond to is astonishing. And there's more work to be done to use that voice to make the points clear about how the law applies to particular facts, and also to make real the longstanding multi-decade civil rights guarantees in federal law, which are only as good as they are experienced at a desktop and in a science lab and on a playing field. And so I would have liked to be able to continue that work so that there's a greater shared national understanding about what we can actually expect for students in schools and what our students have a right to experience when they are in school.
Oh. Um, so this was not your first trip to the rodeo. You had been you had been there, with us and with me
Yes.
during the Obama administration. Can you just reflect a little bit about what was different this time around, during this last 4 years as compared to the Obama administration? What were the most pressing civil rights student concerns that emerged during this period that were the most pressing or most challenging as compared to maybe previous eras that you were involved in?
You know, it's not only not my first time here, so it's nice to be back with you, remembering what we did when it was my first time here, but also Kevin Welner has long been an expert I worked with in litigation before coming to government, so it's nice to come again to that full circle in this conversation too. The on the challenges I see now and how they compared, the COVID context really unsettled all of schools, unsettled all of our, I think, national expectations for safety and norms, and also how we understand our kids to be growing up and to be learning about their world. And so that also had specific civil rights implications. You know, the questions about whether students with disabilities were entitled to their same services during the COVID context. Shouldn't be questioned at all, right? That yes, they were is the answer, and so then they are entitled to compensatory service if they didn't get it. And I am shocked by the number and scope of places where we need to make that point again and again. And then also that unearths unsettled understandings of what a civil rights guarantee actually means. You know, that any of us as educators, as parents, as students, any of us thought that maybe there was a pause on civil rights because there was a pandemic. You know, there's no exception for a pandemic in the civil rights laws, right? And so I am aghast and astounded by the number of times we've had to say, actually, this child was entitled to more and is entitled to service to ensure that child is okay. Separate and apart from that, there's all kinds of new questions about how are we shared learning in a hybrid context, in an in-person context? Is it safe? Is it not safe? Should people have masks? Should they not? You know, all of those questions had particular acuity for students with disabilities, and so that was new and different. And then the broader scope that the COVID context unearthed about how we don't have shared understanding about the application of civil rights laws came up again and again and again this time. Also, you know, in particular, you mentioned the shared ancestry focus that we've had since the October 7 attacks by Hamas in Israel. And we've seen lots more reported harassment in schools. And it was so surprising to me to hear so many school communities say to me, say to the news, say to their students, that they didn't think they had an obligation to act because some harassment was speech or some harassment occurred off campus with implications on campus, et cetera. And those are to me settled questions actually in law. And it turned out that we didn't have a shared understanding in our school districts, in our colleges and universities on that question again, that when you cannot discipline a speaker, which you absolutely should not do when that's protected speech, you still have a non-discrimination obligation to all of your students to ensure that they can learn equally. And I learned there, how many people hadn't understood that, and so you know, a significant need for us to address that question, but that it's also not limited to the shared ancestry context of anti-Arab, anti-harassment, anti-Semitic harassment, et cetera. That it certainly extends also to schools' understanding of how they're responding to traditional race discrimination, also, and it turns out also to sex discrimination and disability discrimination. And so, you know, that need to say again and again that there's a civil rights imperative, and that every student trying to learn is entitled to satisfaction of that imperative is distressing. So there's a sameness and a not on that. That was very new to hear the quantum of need there, but it also reminded me the first time I came how many conversations I had with college and university leaders, school district leaders who would say, well, if we're trying really hard to address sexual harassment, can we have an exemption from enforcement under Title IX? Well, there's no exemption in Title IX for that also. So again, I appreciate the effort, appreciate the trying. You have to actually satisfy the obligation to every student every day, all the time. That is the promise in our civil rights laws. The civil rights laws, as Congress wrote them, saying no person shall experience discrimination as protected in law. So again, that newness and repetition of needing to be clear that our guarantees in law need to be our students' actual experience every day that they're trying to learn is frustrating to me and challenging, and I think challenging for all of us.
Yeah, I heard clearly the pandemic had a big impact this second time around
Yes.
and reverberates in ways to public education writ large, you know, and the
Yes.
challenges. Definitely hear that, as well as some specifics around October 7th and what happened and how that both reflected new and old challenges in
Right.
enforcement. Before we turn a little bit to the future, I want to just give you a chance to. I know that many of us on the webinar today have been waiting with bated breath on many announcements, many things. They're just like, "Oh, Catherine's coming today," so this is your chance to maybe talk about things that have come out recently, things that you want to stress for us as we look ahead to the next administration. What are some just reflection on any recent announcements, accomplishments that you think as advocates, as the non-governmental sector that we should pay attention to or would be useful potentially to us in our future work?
Great, great. Thank you. We've had already today 4 big releases, and I'll share with you that we have a 5th still coming. So we talked in the 4-year retrospective report
Heard
about
it here
64.
first.
Yes, 64 policy releases in this administration, which is amazing. There's a 65th coming also. So, I am delighted about our speaking right up until the last day that we get to speak on these topics to the application of civil rights laws to particular issues that come up. And I say that to say I'm glad we did it, but also that ought to be our national expectation for an Office for Civil Rights, period. That in a next administration, I hope we also are expecting that the Office for Civil Rights will tell us as a community how the law applies to the various kinds of issues that come up, and will continue to issue press releases and to publicize and to share the work that it's doing so that we can know and that we can experience the civil rights satisfaction that we are entitled to, and also we can know how the government is applying the law. Most recently today, you mentioned the 4-year retrospective report, which I'm delighted about, and I commend everyone to read for lots of reasons. I think it sets out the way that civil rights work is being done now and how important that is. It also describes case resolutions. It attaches an appendix that has links to PDFs of all of the 64 policy resources that we had released. So should they not continue on our website, they would be in anyone's hands if they would like them moving forward also. And they also describe particular kinds of issues that come up in students' lives. So the application of sex stereotyping to all of us and the ways that the law's protections against sex stereotyping protect all of us in the ways that we show up in the world, and intersectional enforcement, and the various kinds of ways that the law applies. So I think that's a worthwhile document in itself. Then we also released the 21-22 Civil Rights Data Collection, and I think that's hugely important to make that public, to make it useful. We've always had it, and my staff have already had it here in OCR to be able to use that in our enforcement, but we want somebody's mom to be able to use it in her advocacy with her school district, and we want school districts to be able to use it themselves, and states to assess their own equity indicators and to see what does and does not operate. And so we released the data. We released a first look document that walks through data points in it and the quantum of inequity that exists still in schools. And I hope that that is a sobering look for all of us, that we do need to redouble our energies to protect our kids. And I know everyone on this webinar is doing that. So I hope that we recommit ourselves, because we see in those data what we see over and over. This year's reflection includes that fewer than half of our nation's high schools even offer calculus at all. Different question whether it's in sequence and enough, but fewer than half even offer it to any of their students. And then we know that if you are Black, if you're Latino, you are more likely to go to a school that does not have equal offerings than if you are white. And if we know that, and if we have known that for all these decades, why are we not doing more for our kids? Why are we not changing that set of issues? And so I hope that those among so many data indicators are calls to action for us, that we actually need to offer equal schooling on an equal basis to all of our kids, and that it's time for us to actually make that commitment. So that's out in the world, and I hope people can use it. And I think it's an enormously important new release. And then we just had 2 shared ancestry resolutions, one with the school district and one with Emory University, as I mentioned. Those, I think, make very important points, including Emory University. We are responding to gratuitous violence by police when they came to disrupt an encampment at the school. And it was the school president, the school itself recognized how dangerous that was for the students. think that's important for us to be thinking about in this time when there's increased polarization in education, there's increased conflict about what should and shouldn't be at school. Nobody should be beaten when they are there. That should be a baseline, and that should be something that we are sure to address. And so that there we are. We had a lot to say today, and we've had a lot to say every day. And I hope that all of us, I included, when I'm no longer at OCR, will be able to ask for and receive from the Office for Civil Rights the continued use of its voice and the continued use of its aggressive, robust enforcement mechanism, which is its charge. So that should be our expectation.
Yeah, leaning into that a little bit more, Catherine, Kevin and I had discussed before you got on some just concerns around the next administration. Certainly the federal budget issues are alone a concern, what's going to happen in the future for states and school districts. We talked about vouchers, expanding vouchers and discrimination. But also we introduced that there are so many civil rights concerns for particular student groups
Right.
and really worries about the Department of Education overall and the both the size and the priorities of the Office for Civil Rights in particular. Um, so what are your chief concerns, both substantively in the legal work and also operationally as we enter this new period in both federal education policy and federal civil rights enforcement policy? Can you talk to us about your concerns and just maybe a little bit more about the role and significance of OCR and its future?
Sure, sure. I mean, I'm not particularly well positioned, particularly in this chair, to speculate about what is to come. I am well positioned to talk about what we've done and also what worries me in the things that the incoming administration has said it will do. And so either will or it won't. But having said that it is interested to narrow application of Title IX, that worries me. That the guarantee in Title IX is that no person shall experience discrimination, and we ought to be sure that we expect that every student experiences that, and that we have robust enforcement to ensure that is their experience moving forward. Likewise, the last time there was a Trump administration, the Secretary of Education at that time testified to Congress that she couldn't think of a time when there might be a need for civil rights enforcement. And I think that is jaw-dropping. We thought of nearly 23,000 times alone in the complaints that came in a single fiscal year in FY24, because that's how many complaints we received. Those people thought that there was a civil rights issue that needed redress. And what we see in our investigations in school after school after school is that there are civil rights issues that need redress. So we need the anybody sitting in OCR, anybody sitting in the Department of Education to understand that the Department of Education is a civil rights agency, and that the job of the Office for Civil Rights is to make sure that these beautiful guarantees are actually what students learn under in schools. So I worry about our commitments to those sets of goals. I also know from the budget requests the last time there was a Trump administration that the budget requests were specifically to reduce our enforcement staff and to increase the volume of cases that each investigator held to an untenable caseload. And that's not speculation. That's actually what the budget request said was the goal. And Congress happily gave OCR increased funds during those years, but they were not spent on enforcement. And so that made more challenging the enforcement results. And given the volume that we're seeing, we desperately need to have increased appropriations and funds from Congress moving forward, including in the next administration, and to see that those funds are spent on enforcement and making sure that our staff are able to efficiently and effectively respond to the kinds of concerns that people bring to them so that we can see the relief that people need. So my worries are that OCR may not receive those funds from Congress. That's been my experience in the last two budget cycles, and that's been very challenging for us, and or that OCR would receive them and that they may not be effectively spent. I think that's an important point to monitor. That having the dollars only gets you so far. You have to actually spend them on the right things, and then I worry about the quantum of commitment to the full scope of civil rights issues. incoming administration is certainly quite performative in its descriptions of civil rights issues and its responses in its at least in the candidacy stage. And if we stay performative, I think that's not responsive to the actual experience for kids in schools, because the civil rights are not political. Civil rights laws have been bipartisan for 6 decades, and we've had bipartisan commitments to the need for that federal backstop against harm. And if we politicize what we're doing, we we put we put our kids in danger, because what they're trying to do is learn math. What they're trying to do is to focus on reading in school, learning their essays, learning civic engagement. And if instead the lessons that they're learning are that their their experience of learning is political and politically dependent, that's quite dangerous for us as a democracy. So I worry.
And sort of related to your, sounds like very accurate and apt worries. We, among us, include some national legal and policy organizations like ELC, where I am, but also many state and local advocates. I think about what you mentioned, 23,000 civil rights complaints last year to federal OCR, the 56,000 resolutions you
Right.
achieved in 4 years. Now we are entering a new period. Clearly, tip of the iceberg in terms of the actual civil rights complaints out there in the universe that may shift to state and local organizations or governments. So can you just talk to us about, how, in your view, like how should states and advocates how should we prepare for the next administration, if that's a sort of a fair way of asking it? Or maybe what should we be doing now that we might not be doing to protect student rights? What can we do, assuming there's funding and will and capacity in our sectors? What can we be doing now, and ought we to be thinking about and preparing for?
So this is my favorite question, because what we should be doing now is what we should be doing all the time, right? There's every year is a new opportunity to discriminate against kids, right? We know that, and there's new compositions in schools that they are constantly shifting by design, and so there's new opportunities for conflict, and we need to be vigilant all the time. And I think it's been a mistake that we have relied so heavily on the federal safety net as distinct from operating state and local safety nets as well. And what I see is that we don't have enough places that have robust civil rights enforcement offices, applicable to schools, applicable to civil rights more broadly. But we know that there's no shortage of civil rights violations, civil rights harms all over the country, right? No matter where we are. And so it's important to have uh, to have the reliance on the federal government, because there should ultimately be this federal backstop against harm, but our own safety nets in our cities, in our towns, in our states, where we are. And that can be actually having enforcement offices, which would be terrific. It also can be what you're describing, that the advocacy organizations and the attorneys general and the city attorneys offices doing their part to ensure that state, local, federal civil rights laws are fully experienced and fully enforced. And so I hope we will still use the Office for Civil Rights. I hope people will still rely on the federal government, and I also hope that we are more vigilant about building, sustaining the separate and addition safety net. Because what I know, and we talked about blockbuster numbers, which I'm so proud of, but in truth, there's 18,000 school districts in the country. There's more than 6,000 colleges and universities. And so when I received in my office 23,000 complaints nearly in FY24, that's not even one per institution. And we know that there's more than one per institution civil rights concern to be had. And so we just are not built to be there for every kid who would need us in the way that we need to be. And so we should be building that so that every kid, every day, learning in every school has confidence that they will be cocooned and supported for the valuable learner that they are, and also that their rights will be fully protected.
Thank you. We are going to turn to some Q&A for you,
Okay.
Catherine. But this is our segue. But before I do that, I just wanted to give, I didn't want to, dominate the triangle here. So Kevin, if you have any questions or reactions for Catherine, I wanted you to give you the chance to do that before we turn to other Q&A.
I have oodles, but I think let's go to the let me actually one of the questions in the Q&A, I'll rephrase it and ask it. It's about filing. The question was about Title VI complaints, but you could think about it more broadly. Given what you've described of what you anticipate in terms of what happened in the last Trump administration, what is the value of filing a Title VI complaint? What is the value of filing a Title IX? Given what's likely to happen in the next administration, I'm sure you're not going to say don't bother filing. So I'm curious if you could articulate why. What do you see as the benefit of filing those complaints?
Well, first, the law is what it is. And so bringing deepest hurts, which families do when they come to the Office for Civil Rights, to the federal government to ask for redress is right and righteous, right? It's saying, I think that something was not right for my kid, and I am entitled to redress. Here's what the law is, as described on our website, or as described, if somebody has counsel and has read the statutes. The office, if the office has said that it won't take jurisdiction over particular issues, there's no point in filing. But where there's not that answer, then come and ask for redress. And the among the many beautiful things about the Office for Civil Rights is that you don't have to have counsel, you don't have to know the law, you don't have to say magic words to be able to get relief. You can come and say what you think is wrong, and our expert staff will assess it and bring their expertise to bear to identify what change could be necessary, and if change is necessary for a school community. So there's value still in doing that, unless the Office for Civil Rights has just said we aren't doing some particular area of law. I don't know that I would place all my eggs in that basket. That there might be other avenues for relief as well. But I always think that's worthwhile, right? I always think it's a good idea to go to your school district first. It's a good idea to go to your university administration first and to say what you think should be different, because I get relief, and that would be worth it. And that's certainly worthwhile doing. But I absolutely wouldn't counsel somebody not to come to the Office for Civil Rights, because I don't want any of us to forget, including the Office for Civil Rights, that the law is what it is. And there are court decisions that are binding that say how to apply it, and people ought to be able to expect relief from their federal government, consistent with those laws.
I think we have so many questions here that run the gamut across the spectrum of race, sex, and disability rights. So maybe let's stick to Title VI for a second here. Catherine, any more sort of thoughts about how OCR would address Title VI disparate impact cases under the new administration? I'll also stick in a question about immigrant students and the concerns around immigrants, undocumented students. Any comments about either of those things?
Sure. That I really cannot speak to what is or is not coming in the new administration, because nobody in the incoming administration has talked to me about that. But the question about how does disparate impact law apply? There continues to be a regulatory requirement that federal offices for civil rights, including mine, consider unlawful, unjustified disparate impact in their investigation of Title VI cases, and so we do. The United States Supreme Court has recently, multiple times, talked about the application of disparate impact in, for example, the Students for Fair Admission litigation, and most recently, in a cert denial in the Boston Parents Coalition case, which is a case about use of race in admissions in the K-12 context. And there's a dissent from Justice Alito that says that under an Arlington Heights standard, I may be getting too lawyerly for people, but under a particular standard for evaluation of intentional discrimination, review of unlawful, unjustified disparate impact can be a way of evaluating intent. So, this is something that the United States Supreme Court is telling us is a robust tool. And so I would imagine that any civil rights enforcement agency would continue to use any robust tool. And so I think that we can continue to expect operation of the law from our government as long as the law is.
That Alito comment signals a related issue, which is essentially what he's getting at is we can imply discriminatory intent by people who are attempting to remedy past wrongs for vulnerable communities, right? That's where he was given the context of the case. And I wonder, before you got on, we were talking about other contexts where civil rights laws or protections have been used essentially to undermine rights. So I was discussing the free exercise issues, but there were also other issues, and the affirmative action cases out of Harvard would be another example of that. And so when you look at the potential, I know no one's talked to you about the next 4 years, but when you look at the way that OCR might be used, do you see that sort of shift from shield to sword?
Uh, your question assumes that we have not been a sword before now, so that there's a shift to be had. And
Particular type of shield, yes.
yes, I think that the answer to that question often assumes a subject position. The OCR is of necessity a shield, and I think it will always be a shield against harms that the OCR leadership, that a particular administration recognizes, and I don't imagine that goes away. You describe OCR also as a sword. Some people say that we've weaponized it in this administration. I mean, there's lots of ways to view what we do. I believe in robust enforcement of federal civil rights law. If the next administration does as well, I will be excited about that. I have very high hopes for a shared understanding and complete fealty to the law as Congress wrote it and as courts have interpreted it. And I will look forward to a future where we continue to see that.
Moving on to Title IX, we have the regulations from Biden administration for Title IX currently. Thank you. We know that there are disagreements between administrations on Title IX. Can you just tell us generally about your thoughts about Title IX, what it contains, the protections therein, and what either your concerns are or advice to us moving forward around Title IX and its scope?
Sure. Well, just to be concrete, last week, a federal district judge in Kentucky vacated the 2024 Title IX regulations nationwide. And so they are not in effect anywhere right now. The litigation is ongoing, so we'll see what the end result is of that. But at the moment, the 2024 regulations are not in operation. And I don't know the answer to what the next administration will or will not do with respect to those regulations. I've seen language in the trial court opinion in that case that was unclear about what the next steps are. And I've seen some of the litigants in press release statements suggesting an open question about what the next administration will or will not do with respect to the regulations. So I don't know the answer to that. What I do know is that the Title IX guarantee in the statute is that no person shall experience discrimination on the basis of sex. And I do know longstanding doctrinal application of Title IX to all forms of sex stereotyped harassment and discrimination in schools, and that the 2020 regulations themselves promised, was a promise in it, that the department will not tolerate, and that's a quote, will not tolerate discrimination that meets the definition of sexual harassment in the 2020 regulations against any person, including LGBTQ persons. So, that is what the department promised in 2020. I don't know what it will promise later in 2025, but I do know what the law guarantees.
Thank you. I think we have time for just one more quick round of Q&A around disability rights. Sorry, some of these are very depressing, but just we see well, there was a specific question about the possibility or the future of 504 regulations, and also the just signs that our leadership and top officials may be exhibiting signs of discriminatory comments or slurs against the disability rights community. But do you want to just talk generally in the last few seconds about disability rights and what you foresee?
Sure. I had very much hoped that we would we would publish a new Section 504 regulation. It's certainly time. It's been almost 50 years since we first did, and it certainly needs updating. So because we ran out of time, we didn't publish one. All of us can know that there's a regulation drafted and ready for publication. And it would be, if I were an advocate with the Department of Education, I would be asking for that regulation so that we would have the update. And I would be expecting a short timeline for its publication because it shouldn't take that long, given that there's a draft ready for consideration. And I say that to say there is a crying need. Our kids need updated regulations that describe the ways that disability discrimination can occur, does occur, and the expectations for school communities so they have a better understanding of what they should be doing and greater clarity for enforcement in the federal government and beyond.
Thank you. Okay, we should update our knowledge of FOIA and how it applies. So thank you for that. For that last parting words about that, Catherine. So we are at the conclusion of our webinar. So I want to thank both you, Catherine, especially during these final hours, and also you, Kevin, for joining us for this webinar. This will be posted on our website for those that may not have been able to join us for any of it or for some part of the hour. But really thanks to you both, and thanks to all of you attending today's webinar. We are all in a joint mission to protect students' civil rights and equity and non-discrimination in our schools. So we can end on a parting hopeful note that because we are all here and we're in community with each other and we're in dialogue, that there will be a future for student civil rights and that we will get through the next 4 years and use all the tools that we have to ensure equity in our schools. So thank you, our panelists, and thank you all for attending today.
Thank you so much. Appreciate it.